Carry on my wayward son. There'll be peace when you are done. Lay your weary head to rest. Don't you cry no more.
On July 11, 2001, Handlin, Ham, Bennett, and Clapp were indicted. Handlin was charged with a total of 8 counts, including conspiracy to defraud the United States. At the close of a 6-day trial, Handlin was found guilty of all the charges against him.
According to the Illinois Criminal Code of 1961, conspiracy is an inchoate offense and is committed when one party agrees with another to the commission of an offense, with intent that the offense be committed. An individual can only be convicted of conspiracy if proof of an alleged act that furthers the agreement committed by the indicted individual or a co-conspirator is furnished. Even if the person or persons with which the indicted individual conspired were not prosecuted or convicted, were charged with a different crime, were acquitted, were not amenable to justice, or lacked the capacity to commit a crime, the indicted individual is still liable for the charges brought against them relating to the conspiracy.
Handlin was sentenced to 180 months in prison and 3 years of supervised release, and he was ordered to pay $655,639.06 in restitution and $800 in special assessments. Handlin appealed.
The issue within the case of U.S. v. Handlin was that the court had to determine whether or not there were multiple conspiracies or one broad overarching conspiracy.
There is no reason to sever the conspiracy count from the counts related to the Joe's Company store fire or those related to the staged accident. The centerpiece of a charge of conspiracy is an agreement. There is rarely proof of a formal agreement, and an agreement must be established by examining the relationship, conduct, and circumstances of the parties. The overt act requirement is satisfied by even an insignificant act in furtherance of a conspiracy. The mens rea of conspiracy is the intent or purpose that the object of the agreement is accomplished.
In defendant Handlin's trial, Rogers testified that Handlin told him to steal cigarettes from Ham's business. That testimony indicated that Handlin had told Rogers to do this since Ham had not paid Rogers in full for the time when he burned down Joe's Company store in 1991. It showed that the relationship of the conspirators was intricately related to the evidence of the arson at Joe's Company store.
The plurality requirement provides that a conviction for conspiracy requires at least 2 people possess the intent to agree and the intent to achieve the crime that is the object of the conspiracy. This joint or bilateral approach to conspiracy is distinguished from the Model Penal Code's unilateral approach, which examines whether a single individual agreed to enter a conspiracy rather than focusing on whether 2 or more people entered into an agreement.
RCW 9A.28.040 states that a person is guilty of criminal conspiracy when, with the intent that conduct consisting of a crime be performed, he or she agrees with one or more persons to engage in or cause the performance of such conduct, and any one of them takes a substantial step in pursuance of such agreement. With this, Handlin's case would definitely fall under criminal conspiracy in Washington state and would also be considered one large conspiracy rather than a number of smaller ones.
Supporting cases include U.S. v. Noble, which occurred in 1985, in which the court held that various people knowingly joining together in furtherance of a common design or purpose constitute a single conspiracy.
In 2001, the University of Washington Center for Urban Horticulture was torched by a firebombing. Later that year, the final arsonist, Justin Solons, pled guilty to conspiracy and arson. UW suffered $3 million in damages from a fire that was set by the Earth Liberation Front, also known as ELF. This was connected to a string of 17 arsons set across the West set by the Earth Liberation Front and the Animal Liberation Front. According to the plea agreement, Solons built the fire bombs in a clean room behind an Olympia residence and then transported the bomb to Seattle. When the arsonist arrived in Seattle, Solons remained in the car as a getaway driver. 15 people have been convicted of crimes related to the string of fires. This shows how a pattern of specific instances of arson can constitute a whole conspiracy.
A conspiracy charge provided prosecution with various advantages, such as joining the conspirators in a single trial and bringing the charges in any jurisdiction in which an agreement or act in furtherance of the conspiracy is committed.
In the case of U.S. v. Handlin, the court held that a reasonable juror would find that there was the existence of a single conspiracy beyond a reasonable doubt.